Jody, great to see you again. Let's talk a little bit about what we just heard from the defense attorney, Eric Nelson, who is still in the middle of making his closing arguments. He feels he has a lot of points to get to. I want to talk about one of the points that he was pretty clear about making, which is that you have to sort of take a step back from the sort of horrific 9.5 minutes that so many people are familiar with through the video and consider the totality of what Derek Chauvin was experiencing, starting with 17 minutes prior and including the actions of the crowd that may or may not have felt threatening to the officer. And all of that, you have to consider all of that and decide whether this police officer acted in a reasonable manner. Do you think that that's an important point for the defense to make?
Crucial. And he's going into excruciatingly granular detail, right? He's not running away from the video that, many might say is itself so shocking and emotionally triggering that maybe he would want to avoid it. He's saying, no, I know the prosecution has shown it to you as a damning, indicting video. I'm going to wrap my arms around it and go in minute detail and point out, frame by frames in some cases, how what my client did was not really that unreasonable under the totality of the circumstances, as you point out, as a reasonable person under the totality of the circumstances. And that reasonable person standard is a vehicle for the jury to express sympathetic identification, potentially with the defendant. It's a very flexible standard, the reasonable person standard. And so, yes, he is saying, I'm not running away from the video. And you saw this happen in the Rodney King case, too. In the Rodney King case, the Simi Valley jury acquitted the 4 officers in the first trial after the defense went into minute detail in that videotape beating of Rodney King, frame by frame. They didn't run away from it. They ran to it and somehow, in a way, desensitized the fact finders, the jury, to it, and then were able to make a lot of headway.
Right, that's a very good point. I was sort of curious about why the defense kept showing the video, which has been largely understood to be helping the prosecution, right? And we kept going to the video and we kept seeing, these awful moments in the video. But you're right, there could be an element of just trying to desensitize everyone to it. Jody, we've seen hours of emotional testimony in this trial, as well as some that wasn't so emotional, the more technical and medical stuff. So is the defense then here trying to take everybody out of an emotional space and make it more of these are the facts, these are the boxes we have to check, this is what the prosecution has to do, and I believe, as the defense attorney, the prosecution hasn't done that. Is that what the defense is trying to do here?
Sure. Well, certainly with the causation material, especially, because that's about a kind of scientific question, if you will. Did A cause B, right? It's a kind of factual question. But there are 2 other big questions at the heart of this. Even if his behavior did cause the death of George Floyd, was he in the wrong? Did he do anything morally culpable, objectively culpable, right? And the defense is saying he was really an ordinary person. He was an ordinary officer acting in policy and acting in a way that's justified. And they understand that the jury has to make this moral judgment of this defendant. Criminal trials are about moral condemnation. And so at the end of the day, the defendant is saying, don't morally condemn my client, even if you think he made a mistake. That mistake was only an expression of ordinary human frailty.
Well, Jody, interestingly enough, Eric Nelson also asked the jury to consider whether this was the natural result, George Floyd's death was the natural result of the defendant's actions. And he used an example, which I thought didn't really help his case very much, where he said, look, if you were a police officer and you put you put the suspect in the back of a van, handcuffed, windows rolled up, it's 100 degrees outside, and you leave, and the person in the back of the car dies, then you're responsible for that, right? That's a direct result of your actions. But then, he made an example. To me, that example seems to be sort of close to what actually happened in this situation. So I wasn't sure that really helped his case. What did you think of that?
Yeah, you're right. See, this causation question is a value-laden question. It requires a value-laden judgment. You think it's just, A, cause B. It's like it's raining outside. What is your blood pressure? They are empirical questions that just require a factual judgment. But as we're seeing, medical examiners can reach very different conclusions because they're bringing different values and frames of values to the question. And so he's trying to put it in the jury's mind that when it comes to causation, this natural cause, this natural result is an open-ended, flexible requirement. You jurors, if you sympathetically identify with Derek Chauvin, but you cannot argue that what he did was justify the act or excused, you can still protect him from criminal liability by saying, I don't buy your causation argument. And your causation determination can really be influenced by your values and who you identify with and don't. And so he's trying to get that in front of the jury.
Then he's also interested in this question, or at least he's emphasizing this question of intention, correct? What did Chauvin intend? And so that's why he played back some of the video to show here at this point, Chauvin was clearly saying, I'll roll down the windows or I'll do this. He was showing that he was trying to be more accommodating, or that's how the defense attorney is trying to posit it. And so he is attempting to show the jury a little bit of what was in Derek Chauvin's heart, shall we say, even though Derek Chauvin will not testify himself. So how do you think that's going to play? I mean, I know the jury is not supposed to consider the fact that Derek Chauvin has decided not to testify as any indication of guilt or otherwise. But when the defense attorney is trying to talk to the jury about Derek Chauvin's intentions, it makes you wonder why we're not hearing from the defendant himself.
Yeah, there are two inquiries here. One is into the defendant's head and another is into his heart. The part that's into his head is, did he purposely do wrong? And that's the second-degree murder charge. That's the felony murder count, right? The idea is if you purposely or intentionally assaulted George Floyd in an unlawful manner, then you have you're liable for murder, right? In other words, it's a way of finding murderous mens rea without having the jury determine that he had a depraved heart or that he was engaged in extremely, reckless behavior or ultra hazardous behavior of any kind. You can just say he intentionally committed an assault. He did something intentionally that was out of policy. And that's all we need for murder. And so it's a felony murder rule. And a lot of times people criticize that rule because it really gives you an increase in the amount of punishment you're subject to, even though you may have only been guilty of a mere assault. You say, okay, assault is bad. Maybe you get somebody, but it can turn into a murder count if they consider it part of the felony murder rule. So he's trying to shoot down the felony murder rule, and then he's trying to go to the heart. And he's trying to say, if you had no intent to do something unlawful, so you can't trigger the felony murder rule, then the only other way you're going to find him criminally liable is for unintentionally causing the death. And unintentionally, defining guilty of unintentionally causing the death, then that's either manslaughter, he was negligent homicide, gross deviation from a reasonable person, or third-degree murder. He was so reckless that he showed extreme indifference for the value of human life. And so murderous men.
Right. So are you surprised at how long the defense is taking to make, their closing arguments, or does this seem natural for a trial of this sort?
Well, yeah, it's difficult. Clarence Darrow, one of the most famous trial attorneys in American history, sometimes had 3, 4, 5 day long closing arguments. Sometimes, right? It depends on what you feel you're up against. And this defense knows that it's up against a mountain of publicity, a lot of feelings that have been expressed. This jury hasn't been sequestered up until now, right? So this defense knows that it's up against a lot. And so it's going to try to, as much as possible, challenge some of those common sense intuitions, challenge the received wisdom on this quick case. And when you're challenging received wisdom and, what a prevailing opinion is, that means you have to work extra hard, put in extra time, go into kind of granular detail he is, and we'll see if it works out. But it doesn't surprise me that he's putting in this much effort, because to much of the world, this seems like an open and shut case. But he's trying to show the world that it's more than just that.
And does the defense have unlimited time to make its closing arguments? Is there a limit?
Oh yeah, yeah. You know, it's kind of. I hate to make the analogy. You know, it's kind of like a baseball game. There's no clock on a baseball game. It's not like a basketball, football game, right? You go until the last inning. You know, until the last pitch. And if I'm the defense, I want as much time. I'm sure. You know, of course, it can't take years or months, but you know, within reason, as long as I think I'm making headway with the jury, I'm going to say, Judge, let me keep making headway with this jury. I'm up against a mountain. Right, I have to climb Mount Everest here to get over this hump with this jury. Give me the time I need, and that's what due process means with my client. So at some point, you know, you can go way too far, but you have a lot of discretion in things like this.
So we don't know whether the defense will finish its closing argument today. I mean, you just made the example. This could go on till tomorrow. We didn't expect that, but it could. And once the defense does finish its closing arguments, the jurors, of course, will be sequestered in this case. Can you talk to us a little bit about what that part of the process will be like for them?
Oh, yeah. You know, after the defense closing, the prosecution will have a rebuttal, and then you're right. Deliberation time and under sequestration, so you know that there's going to be some pressure felt by many of the jurors to really cut to the chase and not dally and not, you know, allow any time to be wasted if possible, so that they can get back with their families and get on with their lives. They're doing an important civic duty, but they don't want it to be too onerous. So they're going to go in there, and they haven't been sequestered to now. So they've heard about things like Dante Wright, right down the street, 10 miles away from where this is going on. They've heard about things like Adam Toledo, right down the street, right? And they could see this as part of a pattern. They're not supposed to. They're supposed to try to drown that out. Now, I think the judge perhaps should have sequestered them sooner for this very reason. But here we are. Mm-hmm. So now they're going to have to go in there, and it's going to be a very tough deliberation process, because they're going to have to make not only these causation determinations and get caught up in all the scientific evidence, but they're going to have to make judgments about Derek Chauvin's heart. Right, whether his heart only makes him liable for manslaughter, or if his heart should make him liable for murder, or maybe the nature of his heart should make him liable for nothing at all, because if he made a mistake, if he did act out of policy, it was just an ordinary expression of human frailty. Police are people too.
Professor Armour, I want to ask you, I thought the prosecution did a really good job of speaking directly to the jury and reminding them of what their duty was here. You know, of course, it's always hard to sit there and imagine that there's a man's fate in your hands. But he said there were bystanders who were powerless to do anything about what they were watching, because they had to obey the state. They had to obey the law. They could not step in, and stop the actions of a police officer. He said, but you are entitled, you are given that power, and it is your duty to use that power when the state oversteps its role. And I thought that was actually a very strong moment in the prosecution's closing argument, because it reminded the jury that if they decide that he is guilty, to not do anything about it, to not take their role, would actually be shirking their responsibility.
Oh, yes. It's awesome, the responsibility that comes with jury duty. And he's driving that home to them, that you do have an opportunity to, protect citizens against the state. And these officers represent the state. They're state actors. They take an oath of office. They act under color of law. They act on the behalf of all of us. So they make us complicit in what they do. And so this is your chance to say, state, you have limits on what you can do. On the other hand, also jurors are there to protect the individual against the state. And there's a sense in which the individual here is Derek Chauvin, the defendant, and the state is who's prosecuting him. And so the defense attorney is saying, yeah, by the same token, jury, protect this individual against a state that may be overzealous in its prosecution of him.
Right. Yes. No, you're right. But I thought the way the prosecution sort of cleverly put the jurors in the minds of the powerless bystanders was a clever sort of conceit there. of course, Professor Armour, the jury's decision must be unanimous, and proof beyond a reasonable doubt is a high bar, as of course it should be in a murder trial. So do you think that we could see a mistrial in this case? Do you think we could see, a guilty charge in only, or a sort of a, guilty ruling in only one charge, for instance?
So yeah, we've seen compelling video evidence, but would result in acquittals before. The first Rodney King trial in the Simi Valley jury in '92 resulted in acquittal in spite of everything that we saw in the video. And Walter Scott was seen in a video running away from a police officer, shot 6 times in the back. Despite that video, the jury deadlocked. So it's very possible that a jury could either deadlock here or maybe make a compromise verdict, say we could, some of us think he should be guilty of murder. Others of us think maybe he shouldn't be guilty of anything. Maybe we can compromise on a verdict of manslaughter, which is kind of a lower grade of criminal homicide that doesn't expose you to as much punishment. So you may get that kind of compromise move, even though you're technically not supposed to go that way. Jurors sometimes do that sub rosa.
And you do see the defense, he's sort of trying to tackle each one of these charges individually, isn't he? Maybe that's why it's taking so long.
Oh, yeah, he has to march through them systematically. He's saying, one, you're trying to get me for felony murder. I got to knock that out. No intentional, wrongdoing here. Number 2, you're trying to get me for unintentional homicide. First murder, saying that I had some kind of depraved indifference. No, let me get rid of that. And then number 3, you're saying, okay, even if he wasn't guilty of depraved indifference homicide, he was at least negligently guilty of causing this death, guilty of negligent homicide, and we can get him on that. And that's sometimes you can be looking at a year or 2, punishment for something like that, a much smaller penalty. So they have a range of options.
Professor Jody Armour, thank you so much.